I'm learning that the hard way. Mr. Goodrich, how are you?
Doing well, Your Honor. Thank you.
Is the first case Berger?
Burger, yes.
Yeah, Berger. Or Berger. Right, so we're on the record in docket 2401135. That is people in the state of Michigan versus Demoya Berger or Berger. Will the parties please introduce themselves for the record? Mr. Stevens.
Stevens on behalf of the people.
Mr. Goodrich.
Luke Goodrich, Public Defender's Office, here to represent Ms. Berger, who is standing to my right.
And ma'am, you are Demoya Berger? Thank you. This is the time set for a preliminary examination in the matter. Mr. Stevens, how we proceed?
And it's my understanding in speaking to Mr. Goodrich that this will be a guilty plea, specifically to an amended count 1, police officer assaulting, resisting, or obstructing attempted, to 1 year and or $1,000. Additionally, the people have no objection to the defendant's what we anticipate will be the defendant's future petition for Holmes Youthful Training Act status.
All right. So amend count 1 to the attempt charge, the attempt RNO, which is a 1 year and or 500?
1,000.
1,000. Same pack code with an A after it, I believe.
That's correct.
And then there is no objection to 76940 status if eligible. Is that correct?
Height of status.
Height of status. We'll amend count 1. So Mr. Goodrich, I'll restate the plea agreement as I understand it, and then you can confirm it. So your understanding your client will be pleading guilty to the attempt RNO under 750.81D1A. It's a 1 year and or $1,000. With the plea to amended count 1, there would be no objection at sentencing to HYTA status if eligible. Is that correct?
That is correct, Your Honor.
Mr. Goodrich may inquire of your clients of their misdemeanor rights in this file.
Yes, Your Honor.
All right. It's Berger?
Yes.
Okay. Ms. Berger, you have the following trial rights. You understand that you'll be pleading guilty to an amended count 1, which is punishable ultimately by 1 year and or $1,000. Do you understand that, ma'am?
Yes.
And you have the following trial rights in this file, and I'll walk you through those trial rights. All right. You have the right to be tried by a jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond reasonable doubt that you are guilty, to have any witnesses against you appear at trial, to question any witnesses brought against you. You are represented today by attorney Luke Goodrich, and he would be present to contest any charges or cross-examine any witness brought against you by the people of the state of Michigan. Do you understand that, ma'am?
Yes, sir.
You have the right to have the court ordering witnesses appear in your defense, remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. If your plea is accepted, you'll give the claim the plea was a result of any promises other than what's been stated here on the record, or threats that it was not your choice to plead guilty. You'd also be giving up the right to appeal anything from a trial. Since you won't be having a trial, you'll be pleading guilty instead. Is it my understanding today it is your wish to waive your trial rights and plead guilty to the amended count 1? All right. I'm going to have you raise your right hand, ma'am. You solemnly swear affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury. All right. I'm going to bring your attention back to April 16th, 2024, at the offense location of City of Lansing, 541 East Edgewood. Were you at that East Edgewood address in the City of Lansing on April 16th, 2024?
Yes, Your Honor.
And at that time, did you attempt to assault, batter, wound, resist, obstruct, oppose, or endanger Officer Nicholas McKeeby at that address at that time?
Yes, Your Honor.
Why don't you tell me what you did in regards to the assault, batter, wound, resist, obstruct, oppose, or endanger?
He tried to redirect me. I walked away because I asked him, can I get my belongings? He called me. That was it.
All right, and you knew he was an officer at the time.
Yes.
All right. So I would find that to be an attempt under the opposed. Anything towards the factual basis, Mr. Goodrich?
No, Your Honor.
Mr. Stevens, are you all good on the factual basis there?
People are. Thank you.
All right, thank you. I find the factual basis to be knowing, voluntarily, and accurately made, and I will refer to probation for a report to be done. And really what they're gonna do is they're gonna go to the 5th floor, they're gonna ask a bunch of questions. They're gonna prepare a report for me and we'll see what options are available to us in sentencing, all right? They're mostly gonna be looking at that YTA status because they're gonna have a recommendation from me, all right? All right, sentencing date for
June 28th at 8:30.
June 28th at 8:30. So be candid with them and they'll do a report for me and we'll see what options are available to us. All right, ma'am? Anything else for the record in docket 24-01135, Mr. Stevens?
No, Your Honor, thank you.
Mr. Goodrich?
No, Your Honor.
All right, Ms. Berger, we'll see you on that date, okay? Thank you.
Thanks.
Thank you, Your Honor.
What's next, Mr. Stevens?
We can do,
Mr. Feigelson?
yes, because I think we're still waiting for Mr. Carter's person from lockup unless we're gonna do it on the screen.
All
I
right.
wasn't sure, so that's,
He's
I mean,
downstairs. I gotta go get him.
yeah, I figured you might have to, so that's why I'm skipping Mr. Carter.
All right. And Mr. Feigelson, is that Mr. Shea or Mr. Bradley?
It's Mr. C, Your Honor.
C, thank you. All right, so we're on the record in docket 23-03690. That is people of the state of Michigan versus Joseph C. Will the parties please introduce themselves for the record? Mr. Stevens.
Andrew Stevens on behalf of people.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson on behalf of Mr. C, standing to my right this morning, Your Honor.
And sir, you are Joseph C., is that correct?
Yes, sir.
Thank you. This is the time set for a preliminary examination. Mr. Stevens, how we proceed?
Thank you, Your Honor. It's my understanding in speaking to Mr. Feigelson that Mr. C, as well as the people are going to unconditionally waive the right to schedule a preliminary examination. This matter will be bound over to circuit court as charged.
That's correct, Your Honor.
And I'm assuming negotiations are continuing in the matter?
Correct.
Wait, is that? Yeah, okay.
All right, Mr. Feigelson, may I inquire of Mr. C of his waiver?
No, Your Honor.
All right. Mr. C, you understand you have a right to a preliminary examination today. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by Mr. Stephen Feigelson, Attorney Stephen Feigelson, and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It's my understanding it is your wish today to waive your right to a preliminary examination today, have the case go to circuit court where negotiations are going to continue. Is it your wish today to waive your right to a preliminary examination today?
Yes, sir.
Mr. Stevens, do you also waive the people's right to preliminary examination?
I do, Your Honor. Thank you.
I find the waiver of the preliminary examination to be knowing, voluntarily, and accurately made. Now provide the bind over documentation for the parties to sign.
Judge, I can approach it.
Yeah, Mr. Feigelson, if you would, you're going to add that to your job duties.
Yes, sir.
Thank you.
Approach.
You may. Thank you, Mr. Stevens. All right, I find the examination has been waived on today's date. That's 5/4/2024. Before I sign it, your time in district court is done, Mr. Say. You'll get your next date from Attorney Stephen Feigelson in circuit court. All right, sir. Anything else for the record in docket 23-03690, Mr. Stevens,
Nothing from the people, Judge. Thank you.
from Mr. Feigelson.
No, Your Honor, nothing on behalf of Mr. C, Your Honor.
All right, I will sign the documents. And you should be all set. Thank you for your appearance today, sir.
Have a good day, Mr. C.
Then these are on Mr. Williams,
I don't know.
on the Nolly process.
Yes. I did those this morning. I don't know if she was in there.
Hey, Judge.
Yes.
You know if Abby filed a nollie on Miss Rubenschneider, because she pled yesterday finally in front of Judge Dave.
She's not on the docket, so
That's all I needed to know.
She's
So,
on the docket for tomorrow.
she's on the docket for tomorrow.
I have not seen the ballot come through,
But
Mr.
that-
Feigelson.
okay.
That was the expectation.
Yeah, right, yeah.
Yeah.
And I can confirm she pled. because I was
All right.
Standing next to her, we did it.
Mr. Stevens, did you want to put these on the record or for Mr. Williams?
If you want.
Doesn't matter to
No.
me. Yes. All right, so Mr. Woodley, we'll call your case and you can unmute your attorneys here.
Okay,
And I did approve of Zoom on the preliminary examination for the distance, Mr. Woodley, understanding or having some insight as to how this was going to proceed. So we're on the record in docket 2203321. That is People of the State of Michigan versus John Woodley. A counsel's appearances for the record, Mr. Stevens.
Andrew Stevens on behalf of people.
Mr. Mills.
Good morning, Your Honor. Stephen Mills on behalf of Mr. Woodley. Mr. Woodley appearing via Zoom with the court's permission.
And sir, you are John Woodley, is that correct?
yes,
You can hear me all right, Mr. Woodley?
yes,
All right, thank you. This is the time set for a preliminary examination today. Mr. Stevens, you can make a record and I'll let Mr. Milks make a record. It's my understanding there's a request for an adjournment. The assistant prosecutor who was on this case is ill today, and then you can take it from there, Mr. Stevens.
Actually, I was going to defer. I don't like usually deferring to Mr. Milks because I don't get the microphone back, but I'll defer to Mr. Milks on this. Having seen email exchanges between Mr. Milks and Ms. Wilson, I'm certainly, and the court is certainly aware of the sort of the context of where we are today. So with that, I'll defer to Mr. Milks.
Mr. Milks.
Thank you, Your Honor. That is correct, Your Honor. We are asking for an adjournment. This is a request from Ms. Wilson, who last night informed us that she's coming down with the flu. Mr. Stevens informed us today that she was willing to bring herself in, but absolutely no one would want that at this point. So spoke with Mr. Woodley about this. He completely agreed. He hopes that she's feeling better soon. But as the court is aware, this is a very video heavy case,
Right.
and a kind of a complex situation where bringing a new prosecutor the day before is, I think, completely almost unfair at that
Right.
point. So
Yeah, there's been discovery issues and there's a lot of videos here. I will indicate that on November 9th, the defendant waived his right to a preliminary examination within 21 days. There was a stip to adjourn based on some of the reoccurring discovery issues. I agree with this request for an adjournment on the matter. So we will reschedule for a new date. Then we have some continuity concerning the APA on the case, who's been handling the case throughout this inception. And we'll reschedule the adjournment for,
Would May 30th at 1:30 work for all involved?
you know, we know where Miss Wilson will be. How about you, Mr. Milks?
May 30th.
That would be, we're putting aside an afternoon for.
Yes, Your Honor, that should work.
All right. So we'll reset the prelim for May 30th at 1:30. So Mr. Woodley, we've reset this for May 30th at 1:30. That'll be live on the 6th floor of City Hall of Lansing for your preliminary examination concerning this embezzlement case. Anything else for the record in 2203321, Mr. Stevens?
Nothing from the people, Judge. Thank you.
Mr. Milks?
No, nothing from the defense. Thank you.
All right, Mr. Woodley, we'll see you on May 30th at 1:30. You're all set.
thank you.
Thank you. You found his line?
Mine's right here. I don't know what Carter wants. What else you got?
I've got Jamel Williams.
And now we get this one.
Hmm?
And now we get this one.
Mr. Carter, we found your clients here.
Smile later.
We should do this again sometime. Just thanks, Judge. I
Thank you,
appreciate
Mr.
it.
Mills. Mr. Carter, who's your client? Is that Bradley?
Yes. Yes.
Is that Jacarius or D'Angelo?
Jacaris. Jacaris. How do you say it? Jacaris.
Jacarius? And Mr. Stevens, are we ready on that file?
Yes, Judge.
All right, thanks. All right, so we're on the record in docket 2401051. That is People of the State of Michigan versus Jacarius Bradley. Will the parties please introduce themselves for the record? Mr. Stevens.
Andrew Stevens on behalf of people.
May it please the court, David B. Carter Jr. on behalf of Mr. Bradley, who is present standing at council table.
And sir, you are Jakaris Bradley, is that correct? Thank you. This is the time set for a preliminary examination today. Mr. Stevens, how we proceed?
Your Honor, and speaking with Mr. Carter, it's my understanding that he was either recently appointed or retained. I don't know the exact nature of how he came to become representing Mr. Bradley. Nevertheless, as I understand it, Mr. Carter has not received discovery or is in the early stages of receiving discovery. And so it is my understanding this matter will be adjourned. People certainly don't have any objection to that.
And that, Mr. Carter, you can make a record.
I'm conflict counsel.
Your
Your Honor.
conflict counsel,
They
okay.
contacted my office on Tuesday. I filed my appearance at the end of Tuesday, end of the day on Tuesday, in which I have yet to receive discovery, but I'm sure it's coming. I don't fault the prosecutors for that. It's just, I just don't have the opportunity to review it before today.
All right, and so the request for adjournment, I find, is valid. I think we're setting it out in a couple of weeks.
May 30th.
May 30th, you've got it
That's
already?
the first available date
All
that
right.
fits my schedule.
All right, and Mr. Bradley, are you requesting, or are we looking for an adjournment for just cause, or is your client willing to waive the 21-day rule?
I think either or. You're
Okay.
willing to waive the 21-day rule.
So we'll waive the 21-day rule just so that we have it, and your appointed conflict counsel can get the discovery material in order to zealously represent you. Okay, sir? May I inquire of your client of his waiver of the 21-day?
You may.
All right, Mr. Bradley, you understand you have a right to a preliminary examination within 21 days of your date of arraignment. Preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are now represented by conflict counsel, Mr. Carter, who's just filed an appearance, and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It's my understanding it is your wish today to waive your right to a prelim within the 21-day period. You wouldn't be waiving your right to a prelim in general, just within the 21-day period. So Mr. Carter can get all the necessary discovery and can zealously advocate for you in your defense. Is it your wish today to waive your right to a prelim within 21 days? All right. And Mr. Stevens, you also waive your right to a prelim within 21 days. I believe the people have a right to a prelim.
Whether we do or don't,
I
no
can't
objection
remember.
to that.
Right. So at this time, I find the waiver of the 21-day rule to be knowing, voluntarily, and accurately made. And we will reset this for May 30th,
Yes, at 9 o'clock.
May 30th at 9 o'clock. So this has been reset for May 30th at 9 o'clock in order for conflict counsel to get discovery and all the necessary materials. Anything else for the record? 24-01-051, Mr. Stevens.
Doesn't people just think.
Mr. Carter,
No, Your Honor.
you should be all set, Mr. Bradley. We'll see you on that day.
Thank you.
Okay. Are you ready?
See you, Mr. Carter.
Have a good day. Yeah, I'm right.
I'll get
My
on.
wife says hi. You should.
Thank you.
Errol, can you let them know that it's something to start soon?
Yeah.
Thank you.
Five for your here on Harris.
Yes, Your Honor.
I'm assuming that's your case.
It is now.
Mr. Stevens
I was a late-
is vacating the the room.
Mr. Stevens fleeing the scene as quickly as possible. Yes, that makes it mine.
Mr. Austin, you're here on that case?
Yes, I am.
All right.
Yeah, this was initially Miss Rolfs. With her leaving, I am taking on the case.
All right.
A lot. The last several that I've had here, I've
Started by Ms. Rolfe.
either that or I've had it covered. I've had like 48 hours notice.
In custody?
Nope. No, he's here.
All right.
Okay.
All right. So we're on the record in docket 24-01037. That is people of the state of Michigan versus Deshar Harris. Will the parties please introduce themselves for the record? Mr. Pfeiffer.
Yes, good morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Mr. Austin.
Thank you, Your Honor, and good morning. Jared Austin appearing on behalf of Mr. Harris. He is present with me at council table.
And sir, you are Deshar Harris, is that correct? Thank you. This is the time set for a preliminary examination today. Mr. Pfeiffer, how we proceed?
The people are prepared to proceed today, Your Honor.
All right, Mr. Austin, is that your understanding?
It is, Your Honor.
All right. Are there any preliminary matters to come to the court's attention before we get started, Mr. Pfeiffer?
Not that I'm aware of, Your Honor.
All right. Mr. Austin.
Just, Your Honor, I would ask for an order of sequestration. My understanding from speaking with Mr. Pfeiffer, there is quite a considerable amount of support people on behalf of the complaining witness, and I would just like either some type of record or assurance that no one that would be present with her in the courtroom would either be a witness at this proceeding or possibly at trial.
All right.
I have no reason to believe that they would be.
All right. So at this time, there's a motion for sequestration requested. I will leave it to counsel to ensure that nobody in watching reviews any other witness's testimony if they plan to be a witness in this case. And I'll leave that to counsel to let the court know, since you know the case better than I do, if anybody comes in or walks in from outside who may be a potential witness in this case. With that understanding, Mr. Pfeiffer, are you ready to call your first witness?
Yes, Your Honor. The people will call Rosalind Tucker.
All right, Ms. Tucker, you can come up here. Please stand right in front of me. Please spell and state your first name and your last name for the record.
ROZZLYNN, Rosalind, and then Tucker, TUCKER.
Please raise your right hand. Do you solemnly swear, your other right hand, do you solemnly swear or affirm to tell the truth, the whole truth and nothing but the truth under penalty of perjury?
I do.
All right, go and have a seat. I would get as close to the microphone or pull the microphone towards you. That's for recording purposes. So the court recorder can hear you. And then please project as best you can to the back of the room, right, man? All right. Mr. Pfeiffer, when you're ready.
Morning, Ms. Tucker. Ms. Tucker, do you know a Deshar Harris?
I do.
How do you know him?
He's my children's father and long-term partner,
Now, how long is long-term?
14 years.
Do you see him today in the courtroom?
Yes, I do.
Could you please point out where he is or maybe something he's wearing that's unique to him?
In the orange right there.
If the record reflects, she pointed at and has identified the defendant.
All right, I'm gonna have you move the mic right in front of her. Because we can all hear you in the room, but the court officer can't hear you, so talk directly into the mic. Thank you.
And if the record reflect that she's identified the defendant.
Yes, and any objection to the witness identifying the defendant for purposes of prelim, Mr. Austin?
Without objection.
Thank you.
Just do your very best to keep your voice up. I am too. This room really does just eat the noise. Now, do you know a 2238 Westbury Road?
Yes, I do.
And how do you know that location?
That is Deshar's mom's address.
Okay. Now, were you there with Deshar on November 28th of 2023?
Yes, I was.
And real quick, that address, that's in Lansing, right?
Yes.
That's in Ingham County.
Is that a yes, ma'am?
Yes, I'm sorry.
Thank you, you're okay.
Yeah, just make sure you say yes or no, because the recording can't pick up head nods or the difference between aha and
Okay.
It's the most natural human instinct in the world, and you just gotta fight it. Now, did you end up talking with police the early morning of November 29th?
Yes, I did.
And was that about an incident that happened with Mr. Harris?
Yes.
Rosalind, as fast as you're able to, what do you remember about that incident?
So I went over to his mom's house to drop some groceries off, and he was there. The first thing he asked me when I walked in was, "Where's my car?" Because the night before I told him I was gonna have all the stuff removed, even his car off my property. But I didn't. I told him that I was still in my house. We were fine. He said he wanted to spend time with the kids.
Yeah, so what happened next?
So after he spent some time with the kids, he fell asleep. So I was like, okay, well, I'm gonna get my kids ready. We're gonna leave and go home. Well, he woke up and got mad, threw the blanket down, and asked me if I was going to clean up after my child.
And what was going through your head during this?
I knew something was gonna happen because he started yelling and getting very frustrated.
But how did you know something was gonna happen because of that?
Me and him have past history of domestic violence.
So in that history, when he gets like this, he then becomes violent with you?
Yes.
Objection leading.
Response?
I can rephrase.
Okay, I'll allow you to rephrase. No objection sustained.
So he has a history of being violent with you?
Yes.
And that's what made you feel like you said that something was going to happen?
Yes.
I'm gonna object, it's still leading.
Sounds a little leading, Mr. Pfeiffer, so I'll have you rephrase. I'm objection sustained.
Absolutely. So what made you feel like something was about to happen? Actually, let me strike that and ask a different question. What do you mean by something was going to happen?
I knew he was going to start getting violent. The tone in his voice, the way he was coming at me.
So what did you do? What do you remember doing once he started getting loud and aggressive?
I had my daughter in my hand.
And how old is your daughter?
She's 15 months now.
And what's your daughter's name?
Harlow.
So you had Harlow in your hands. What do you remember happening?
I grabbed the blanket. I took it downstairs, threw it in the laundry room. I set Harlow down before I went to the laundry room. Deshar then came downstairs with our 2-year-old son and set him down. He started yelling at me. He ended up pushing me in between the couches that are downstairs in his mom's house.
So there are couches in the basement?
Yes.
And after he's pushed you in between these couches, what do you remember happening next?
My son came in between us. He asked me, he's like, "Mommy, are you okay?"
Did it get more physical, just being pushed between the couches?
Yes.
What can you tell us about that?
He ended up grabbing me by my shirt, slamming me onto the cement floor, choking me, hitting me. He ended up banging my head against the cement. After he was done with this, he took my kids and went upstairs. I grabbed the diaper bag, ran upstairs with them. This was the perfect time that I thought I could call his mom, let her know that I was gonna have to call the police. And after he heard the word police, he came back into the kitchen where I was and snatched my phone from me and wouldn't give it back, hung up on his mom as well.
So I want to unpack that a little bit because there was a lot there.
Mhm.
Now you said that he grabbed your shirt and slammed you onto the floor. What
Yes.
type of floor was this?
Cement.
And what part of you was slammed into the floor? Is it any particular part at that point or is your whole body?
It was pretty much my whole body.
And you said that he choked you.
Yes.
What can you tell us about that? Can you talk about that a little more?
It was both hands around my neck, choking.
Did you have difficulty breathing?
Yes.
You then said that he slammed your head into the concrete floor.
Yes.
Did this appear to be by accidentally slamming your whole body, or at this point was it intentionally?
It was intentional.
And was it just the one time that he slammed your head into the floor?
Yes.
Now, do you remember speaking with an officer Bakri a few hours after this, or an officer from Lansing Police Department?
Yes.
Do you remember telling Officer Bakri that he slammed your head into the floor 4 times?
Yes.
So do you remember today, whether it was the 1 time or the 4 times that he hit your head into the ground? Or is it? If at any point you have difficulty remembering something, I don't remember is a perfect answer to give because it is, I mean, it's honest, it's accurate.
Mhm.
So he then went upstairs, you went upstairs as well, and you were on the phone with his mother, is
Yes.
that right? And once you mentioned that you were gonna have to call the police, he took your phone away. And he hung up on the conversation you were having with his mother.
Yes.
What do you remember happening once he took your phone and hung it?
He started yelling at me, saying, "You know, we don't do this. You know, we don't call the cops." And then he proceeded to grab me by my shirt again and throw me to the kitchen floor.
And what type of floor is in the kitchen?
I don't know.
I mean, it wasn't exactly carpet, right?
I mean, there was carpet, but it was like laminated flooring as well.
So like a tile,
Yeah.
maybe. By carpet, you mean like a rug or something like that?
Yes.
It wasn't exactly soft.
No.
What do you remember happening once he threw you onto the floor in the kitchen?
I was trying to wrestle around to get away, but obviously he's stronger than me. So he ended up flipping me over and choking me again.
Did you have difficulty breathing at that point too?
Yes.
And do you remember how he was choking you during this point in the kitchen?
Same way, 2 hands.
Do you remember how that choking situation ended?
No.
Do you remember if you were had to strike that? Let me try that again. I apologize. Do you remember if you were able to basically break free and run away, or do you remember, or did he just stop?
He just stopped.
Like the first time?
Yes.
So what do you remember happening after he stopped choking you in the kitchen?
He yelled at me. He told me to shut up and not yell and go to the room.
What room?
His mom's bedroom.
Did you end up going to the room?
Yes.
Did you still have Harlow?
At this point, during the choking,
The kitchen check.
yes, yes, yes. I stopped paying attention to what he was doing and I zoned into my kids. My son was behind him screaming, "Mommy, okay," trying to pull him off of me. And my daughter was crawling red in the face, screaming and crying.
So when you ended up going into the mother's bedroom, were your children with you in that room?
Yes.
What do you remember happening in the bedroom?
Picked my daughter up because she was red in the face. She was still crying pretty hard. So as a mother leaving, I picked her up. He proceeded to tell me that if I did not put my daughter down, he was going to slam me and my daughter onto the floor.
Your daughter was how old at that point?
8 months.
Now, you and I talked briefly before this examination today, right?
Yes,
And you mentioned that your daughter was a preemie baby.
yes, yes.
So did that? I don't have children, so I genuinely am asking because I do not know.
Okay.
Does that make your daughter smaller or more fragile than a normal child at that age?
Yes,
And Mr. Harris knew this?
yes. We had also just lost our son, who was my daughter's son.
I apologize for asking, but how did you lose him?
This is
So you have Harlow in your arms. He threatens to throw you and your child down to the ground if you don't weaken your child. What do you remember happening?
I put her down for her safety.
You were afraid that he would do it.
Yes.
And what happened after you put her down?
He told me to walk out of the room, and I did. And then he proceeded to not allow me to get my children.
How did you?
He blocked the doorway so I couldn't get to him.
What do you remember happening next after you've been blocked and not able to get to your children?
His grandma walked in, so his mom called his grandma. His grandma lived right next door to his mom. And she was yelling at us, telling us we had to get out, that she was on the phone with his mother. And
By us, you mean you and the children, or you and Mr. Harris? What do you
me,
mean by
my
us?
children, and Mr. Harris.
Got it. So every individual.
Yes.
Understood. So what happened after the grandma came over and was yelling at him?
My son ran up to me, and so I hurried up, went and put him in the car. Mr. Harris was still not allowing me to get my daughter. He ended up leaving his mother's house with my daughter to his grandmother's house.
Now, is there any custody arrangement in place that
Yes, there is.
was him not allowing you to have your daughter? Was that in violation of that agreement or anything along those
Yes, it
lines?
was.
I'm gonna object this meeting.
How was it leading? I genuinely didn't know.
I'm gonna overrule the objection. I think there was some foundational aspects to it, at least figuring out the nature of the custody order. So I'll allow it. Objections overruled.
Okay.
So was this your time to have the child?
I have sole custody.
Sole custody. Got it. Did you eventually get Harlow back?
Yes, after I seen him walking out with my daughter, I ran to my car where my son was. I called the police, and then I went around the corner waiting for them. Then his father called me and asked me if I was okay and what had happened. I explained to his father that Mr. Harris had beat me up pretty badly and he had my daughter. His dad said that he would be there. in 10
Objection,
minutes.
hearsay.
Response?
I would say it goes to the effect on the listener, not for the truth of the matter, sir.
I won't use it for anything substantive. It's just being used, so it's not offered for the truth. So the objection's overruled, but it won't be used for substantive evidence.
Thank you. Could you please repeat what his father said?
His father told me that he would be there in 10 minutes to grab my daughter, which he was. He came. He'd seen how bad I looked. He went in the house, got my daughter. I hurried up, grabbed my daughter from him, thanked him for going inside to grab her, put my daughter in her car seat and left.
And then did you contact the police?
Yes, I did. I let them know that I was going home because I had both of my children, and that's where I knew it was going to be safest. And it was late at night at this point, and it was past their bedtime.
So you had the conversation with police at your residence?
Yes, I did.
Okay. Now, you said that his father saw how you looked. What did you mean by that?
He's seen all of the bruises around my neck, the blood on my lips, the scratches.
So these were from what had just happened with Mr. Harris?
Yes.
I know this seems like an incredibly dumb question, but it is one I do need to ask. Did this hurt?
Yes.
Where were you experiencing pain?
My throat, my head, and then the scratch marks from all over my face and the bruises on my arms.
Did you end up getting any medical attention?
I did go to the emergency room. They didn't find any significant damage.
There wasn't anything that needed immediate treatment?
Yes.
What emergency room is that?
The new emergency room for Sparrow out in Okemos.
That's the one you're talking about. If I got just one moment, Your Honor, I think I'm.
You may.
Just one. Oh. That was the only other point I wanted to check on. Did you eventually get your phone back?
Oh, yes.
When did you get your phone back?
So after all of the situation, after his grandma came in, I hurried up, went to the room and snatched my phone off the TV stand.
Okay. At that point, was Mr. Harris distracted?
Yes, he was talking to his grandma.
Okay. Your Honor, at this time, the people have no further questions.
Cross-examination, Mr. Austin.
Sure, thank you. Morning, Ms. Tucker.
Good morning.
So this address that you were talking about on Westbury Road, you said that is Mr. Harris's mother's address?
Yes.
But she was not present during what you were talking about was occurring?
No.
And you said you had your child Harlow there, correct?
I had both of my children.
And that would be Harlow, and then was it your son?
Yes.
And both of those are children that you have with Mr. Harris?
Yes.
And other than you, your two children and Mr. Harris, was anyone else in the house while all of these things that you were describing was going on?
No.
And approximately what time of the day or night were we talking about that this happened at?
I want to say like 9:30 because I called the police at 10:43.
At night or in the morning?
At night, I'm sorry.
No, you're fine. And you were discussing earlier in your testimony with Mr. Pfeiffer, you were talking about your head being slammed on the floor. Do you
Yes.
recall that?
Yes.
I believe you stated that occurred one time. Is that correct? In your testimony here today?
4.
I know you later said 4, but initially, when you answered Mr. Pfeiffer's question, you said it only happened one time. Is that correct? And then you said you remembered telling the police it happened 4 times. Is that correct?
Yes.
And now your answer is that it happened 4 times and not one. Is that correct?
Yes.
And you were talking about a custody arrangement with your children. You said you had sole custody. Is that correct?
Yes.
When you say that, were you referring to legal custody or physical custody?
Legal.
What is a physical custody arrangement?
There is no physical custody arrangement. He has revised custody towards my children.
Okay. So there was nothing in place at that time that prohibited him from being around his children or having his children.
No, not at that time, no.
Thank you, Ms. Tucker. That's all the questions I have at this time. Your Honor.
All right, thank you. Any redirect to Mr. Pfeiffer?
Nope.
May this witness be excused from the people, Mr. Pfeiffer,
She may.
from the defense.
Yes, Your Honor.
Right, ma'am, thank you for your appearance. You're excused today.
Okay, thank you.
Additional witnesses, Mr. Pfeiffer.
No, Your Honor.
Do the people rest?
They do.
Mr. Austin, any proofs today?
We'll be relying on the evidence presented, Your Honor.
All
Thank you.
right, thank you. When you're ready, Mr. Pfeiffer, motion for bind over.
Your Honor, to be frank, I am going to be seeking to amend the information, removing one account and adding 4 others. So I just need probably about 5 minutes of
All right.
this, just to make sure I get the pack codes right.
All right.
Eric, let me know when you got it, please. The intended ones, I'm getting out numbers now, but just to get that unlawful imprisonment on the second strangulation, interfering with crime portrait by committing a crime, being interfering with electronic communications, going to be dropping interfering with electronic communications causing injury, death to the normal one. I think that that's been met for the next one of that, and then another domestic violence for the second. So I'm gonna be writing. So I'm gonna be writing all this out real quick, but just give you a heads up. Okay, the people are ready, Your Honor.
Right, we're back on the record in docket 24-01037. Motion for bind over, Mr. Pfeiffer.
Yes, Your Honor. And because of the amount that I'm requesting change, I'm just gonna take these one at a time, slow and steady, to where I don't mess up the numbering like last time.
All right,
First, for count 1, assault by strangulation, I believe there's been sufficient factual basis that she was strangled in the basement by the defendant. His hands were on her neck, she couldn't breathe. For count 2, assault by strangulation, there was a break in these proceedings where then he left. She ended up going up to the kitchen, and then he attacked her again in the kitchen, where he strangled her again. There was testimony that he had his hands around her neck and she had difficulty breathing.
So there has been a sufficient factual basis for count 2. Count 3, I'm asking the court to dismiss at this time. I'm going to ask in a moment that the lesser version of this be included, but I do not believe there's been sufficient factual basis for the interfering electronic communications causing injury or death, because I know the jury instructions are a little specific on what part of the act caused the injury, and that was not here. Count 4 is a misdemeanor, but for purposes of a clean record, I believe there's sufficient factual basis. There was a domestic for the part of this that was in the basement when he was strangling her and beating her head into the ground. Now for the requested added counts. I'm requesting an added count 5 of unlawful imprisonment. The PAC code is 750.349B as in boy. I'm requesting that for the incident that happened up in the kitchen, because we heard Tucker say that she physically tried to get away when he had her down on the ground, and he restrained her to stop her, at which point he then flipped her over and strangled her. So I believe there's been sufficient factual basis for the added count 5 of unlawful imprisonment, because he restrained her in order to facilitate the commission of the felony of assault by strangulation. People are also requesting an added count 6, that being interfering with a crime report by committing a crime or threatening to kill or injure. The PAC code for that is 750.483, A as in apple, 2, B as in boy. We heard Ms. Tucker testify that she was on the phone with his mother and said she was going to have to call the police, at which point he took the phone from her, hung up the phone, kept the phone from her, would not let her have it back, and said, "We don't do that, you're not calling the police." So I believe there's been a sufficient factual basis for that added count, interfering with a crime report by committing a crime where the crime being committed was interfering with electronic communications.
That's a 2-year.
The interfering with the crime report is the 10-year one. The next one I'm going to request is the 2-year.
All right.
I know I always have these together.
All right.
So the added count 7 that I'm requesting is interfering with electronic communications. That is the 2-year felony. The PAC code is 750.5405A. I believe that is a more accurate charge for the facts that were testified to in this case than the initial count 3, which was that would be injury or death. But she was clear. She was actively on the phone. And then she said she was going to make a different phone call to the police. And he hung up the one and stopped her from making the other. And while that might even qualify for 2 counts of that, I'm only requesting 1 today. And then finally, the people are requesting an added count 8 of misdemeanor domestic violence, PAC code of 750.812. I believe that there has been a sufficient factual basis for it, even though it is a misdemeanor involving the fact of the assault that happened up in the kitchen. Once again, there was a clear break here. There is a clear break here in the time, which means that a second charge of domestic violence is appropriate. And then when all is said and done, people will be asking that bond be addressed.
Thank you. Response to motion for bind over, Mr. Austin.
Yes, sir. Thank you. Aware, and I know the court is aware of the burden at this stage, which is relatively low of probable cause. However, it is a burden that the people must meet. This court is the sole determiner of credibility at this stage. I understand from a certain argument how the testimony, I think, on some of these touched upon the necessary elements. However, in response to some of these, Your Honor, I certainly don't think that there was sufficient testimony to support an added charge of unlawful imprisonment. As Ms. Tucker stated, she was able, it sounds like, to get away, to freely get away. So I don't think that there was a sufficient amount of testimony or factual basis that would support adding that charge. Likewise, Your Honor, with interfering with the the crime report. Again, I don't think what the witness testified to would be sufficient to justifying binding over on that particular charge either. Certainly, Mr. Harris did not prevent her, according to her own testimony, from making a call. She could have called the police if she felt she needed to or wanted to, but it sounds like she called his mother. So she was certainly free to do that. I think she would have been free to call the police or anyone else at that time. And as it relates to the added misdemeanor count of domestic assault in the kitchen, Your Honor, normally the misdemeanors just tag along with a felony bind over. But I think it's a little different when they're asking for an additional misdemeanor count. And now my concern is that because seems to be a lot of overlap, I think, on some of these charges about the alleged assault that happened in the kitchen. And I'm not sure that there is a clear distinction from what is being asked for in that added count 8, as opposed to the other accounts that they're asking for bind over on that supposedly occurred in the kitchen. And certainly there was some contradictions in Ms. Tucker's testimony by her own admission. She initially said that her head was slammed into the concrete one time, and Mr. Pfeiffer had to remind her that she told the police 4, and then she changed her testimony to 4. She also stated that she sought medical treatment and did indeed any further medical help because there wasn't anything significant that would require medical treatment beyond that point. I think if someone's head was slammed into the concrete either one time or multiple times, as she testified to, I just don't think that that is credible, and I would ask the court to consider that when making its decision for bind over. And I would, with that, Your Honor, I would oppose the people's motion, and I would ask the matter not be bound over. Thank you.
Thank you, Mr. Austin. Response to the motion for bind over, Mr. Pfeiffer.
Very briefly, to that last point, injury is no requirement for any of this specific in the jury instructions. And we've had cases where someone is beaten to death and strangled to death, and they don't have significant injury shown on them. That is not an indication about whether or not an assault happened or an assault was severe in nature. And that's what we frequently have experts testify to that fact at a trial. Now, as for the concern about the DV not being enough separate from the other things, correct, there is a lot of overlap, because when you commit one criminal act, if it's bad enough, you are committing multiple crimes. That's pretty standard. If you strangle someone, or let me put it this way, if you were to shoot a gun at a person who's your intimate partner and you're a felon, you could be charged with felony possession, felony firearm, felonious assault, and domestic violence, all from that incident. And potentially even where you fire the gun could add another charge on top of that. So that's not a legal concern. It's not a thing. They each have elements that are separate from each other. There is no issue there from a legal standpoint. And then finally, on the interfering with a crime report, she wanted to call the police. She said the words, "I'm going to call the police." And that's when he took the phone away from her and said, "No, you're not." That's pretty much the dictionary definition of interfering with a crime report. Because the elements are not that he prevented her from doing so, but that he tried to prevent her from doing so. And that's clearly what he did. I'd ask that you bind over as requested.
Thank you. The standard for preliminary examination is probable cause. As both counsels indicated, probable cause is the second lowest standard in criminal law. The court finds that location at 2220 Westbury Road, City of Lansing, was made by the witness. The witness was Rosalind Tucker in this matter for the preliminary examination, and the location and venue in the City of Lansing for the date of November 28, 2023. Identification was also made by Ms. Tucker. So location, venue, ID, and date are met at a probable cause level. Now for the elements of the offense, based on the testimony of Ms. Rosalind Tucker, she indicated that they were in a relationship for 14 years. There were 2 children involved at the scene. And she indicated that both those children witnessed some of the events. They're very young. They're very young, these children. But I do find by probable cause evidence, I've looked at this as two incidents, one in the basement and one in the kitchen. So the basement incident, that count one, assault with intent to do great bodily harm, less than murder, which is by strangulation or suffocation, has been met by the testimony of Rosalind Tucker. And I will bind over on count one as an assault with intent to do great bodily harm by strangulation or suffocation for events that happened in the basement of the location of 2228 Westbury in the city of Lansing. In count two, there was a second incident what happened in the kitchen. And I find that the testimony of Rosalind Tucker indicates that the defendant did make an assault upon Rosalind Tucker by strangulation or suffocation at that incident by once again choking her. I find that that's been proven by the elements of the crime at a probable cause level. And I'll bind over on both counts 1 and 2. Count 3 is dismissed pursuant to the request of the prosecutor. Count 4 is a misdemeanor that will attach to the felonies to circuit court. Concerning, I'm looking at domestic violence in that regard at that city of Lansing address, but that did occur in the basement, at least one instance in the basement. Count 5 is unlawful imprisonment pursuant to 750.349B. There's some question of testimony concerning the unlawful imprisonment. However, the witness, Rosalind Tucker, did make the elements by indicating that she was restrained and then assaulted after that event. And so I find that the events pursuant to unlawful imprisonment, being restrained and then committing of the assault GBH pursuant to 750.349B has been met as to count 5, and I'll bind over on that count. There's a request for added count 6 of interference with electronic communications at 10 years pursuant to 750.483A2B. I believe I've heard testimony from Ms. Tucker, plenty of testimony that phone was removed from the incident for the purpose of not being able to contact anyone at time. There's some testimony that she was not being able to contact police once police were mentioned, and that there was also, the phone was actually taken from her person at a point in time. I find the interference with electronic communication based on the 10-year to be met under count 6, and count 7, the electronic interference which is the 2-year, which is the lesser offense to the requested count 3, has been met in regards to taking away the phone and not allowing any type of phone calls and Ms. Rawson makes the argument that you can make a call to whoever you want, but it was fairly certain that she was to make a call to one person or another based on some of the indications when she was allowed to make a call at all, given these circumstances. I find count 7 pursuant to 750.54051A2 is bound over at a probable cause level. So to be counts 1, 2, 3, 4, and 5 are bound over at a probable cause level. The misdemeanor will follow, and then there's an added count 6 of the domestic violence misdemeanor. I'm taking a look at that as happening in the kitchen, where there was a second event of assault and battery. That is a misdemeanor, and that follows the felony counts. So 1, 2, 3 is dismissed, 4 is bound over, 5, the felony is bound over, 6, the felony is bound over, and 7 is attached as a misdemeanor. With that understanding, is that a fair statement, Mr. Pfeiffer?
No.
No, okay.
5 was felony of unlawful imprisonment. 6 was a felony of interfering in the crime report. 7 is a felony of interfering in electronic communications, and then 8 was the misdemeanor of DV.
Okay, 8.
Yes.
So 8, 7, 6, 5, 4 is the misdemeanor, 3 is the dismissal,
Yes.
and then 2 and 1 are the GBH.
Correct.
Thank you.
And
All
then
right.
The people would like to respond.
All right. With that clarification, Counts 1, 2, 3 is dismissed, 4 is the domestic, 5 and 6 are bond over as felony. So 1, 2, 5, and 6. 7 is bound over as felony, and 8 attaches as a misdemeanor. And then, so I will indicate that the preliminary examination has been held on this matter on May 2nd, 2024. And prior to signing the bind over, Mr. Pfeiffer, you indicated you wanted to be heard on bond. Bond is currently set at 15,000, 10% with a GPS and no contact order. Is that correct?
Yes, Your Honor.
Okay, you may proceed.
Now, apart from the arguments that I think bond needs to be raised due to the additional charges that were issued here, in fact, they're more severe as well as effectively doubled. In looking through the case, it does not appear that a bond form is ever actually filed by my office for his arraignment, which means the arraignment judge didn't know about the fact that he's been charged with domestic violence numerous times in the past, wasn't aware of the fact that he had heightened convictions for weapons offenses, or the fact that at the time he committed this offense, he was on bond with Clinton County for a felony domestic violence case, where he is still facing that. And I believe, based on their website, he is set for trial on that in the end of the month. And that is after he failed to appear for the first trial date for that back in March, where a bench warrant was issued for his arrest. And further, going back through his other cases, he has also had problems appearing when it comes to being on probation. So we have a defendant whose cases have now significantly increased, who was on bond for a different felonious domestic violence. And I will note the charges in that were also strangulation and domestic violence with a history of failing to appear. I do not believe that 15,000, 10% is appropriate. I would ask that this be converted to 15,000 cash surety, because I believe that is a more appropriate bond for this defendant.
Thank you. Mr. Austin, you've heard the order of the court for bind over. Your response to the motion to modify the bond at this time.
Yes, Your Honor, I'm opposing the people's motion to modify bond, and I would ask the court to leave it as is in its current form and with its current provisions. The notion that a bond recommendation was not filed in this particular case for the arraigning magistrate, and they're assuming that that would have made a difference, but there's no way of knowing that, as I have seen the arraigning magistrate in instances where there have been a bond recommendation by the people. And I've seen on multiple instances where the arraigning magistrate have set bond much lower than what is being requested by the people in those reports. And the notion that the bond report would have been needed to provide the arraigning magistrate a clear record of Mr. Harris's any type of suppressed files or charged offenses or dismissed files. Your Honor, is someone who, having been present for many of those arraignments, I don't know that I can recall a time where the arraigning magistrate did not have that access to that lien information that would have shown any convictions that would have been suppressed, charged cases that were later dismissed. So I don't think that they have demonstrated that there is any necessary or pertinent information that would have made a difference to the arraigning magistrate. I think the arraigning magistrate had all of the necessary information. They certainly would have been aware of any pending charges. And I'm convinced that they were aware of the pending charges in the other county that the people referenced, because the notes in our file reflect that the arraigning magistrate was made aware of that at the time, simply because there have been additional charges or with heightened penalties. I think at this point is insufficient to change Mr. Harris's bond. He has faithfully appeared to court. There's been no allegations that he is not checking in with pretrial services. There's been no allegations that he is in violation of his tether agreement. There have been no allegations that he is in violation of the no contact order. So I think the current bond in its current form and its current terms and restrictions and all of the supervision that Mr. Harris is having, I think are sufficient. And I would ask the court to leave bond currently as it is set.
Thank you. Any response, Mr. Pfeiffer?
Yeah, I still think that 10%, 15,000 is woefully insufficient for this defendant.
Thank you. Based on representations and arguments of counsel, I do have in the notes that the defendant was currently on bond for myself or currently has a bond on felonies before 29th Circuit Court. So I understand that that was the nature of taken into consideration at the time the 15,000 10% was issued. I do find though that that was based on the charges that were requested at the time. There are 3 further felonies now requested. Two interference or unlawful imprisonment, and then 2 interference or electronic. Those have been requested. Those are additional charges. I also, there's nothing to indicate on the record, and which something that strongly moves the court is a previous fail to appear on another case. Part of setting bond is the reassurance that bond we set bond so the defendant, we know where the defendant is, there'll be no contact, and that the defendant makes the appearance. With the prior fail to appear on other cases, on other exactly typed same cases, that gives the court pause now that this is being bound over on 3 more additional felonies. So I do not believe the request, it's actually a modification in bond. It changes the bond, but I think it's a reasonable request. And I will set bond at 15,000 cash surety and remove the 10%.
Thank you, Your Honor.
So the bond is modified to 15,000 cash surety based on the additional charges and the fail to previously appear. Examination was held on today's date. I will change the bond to cash surety. Anything else for the record in docket 24-01037, Mr. Pfeiffer?
Not from the people, Your Honor.
Mr. Austin. Mr. Austin, your response.
Yes, Your Honor, I think there is one pertinent thing that Mr. Harris wanted me to bring to the court's attention. Obviously, I have no way of knowing or independently verifying. The other case that was the court and the people were referring to where there was a failure to appear. I don't know the circumstances of that, and I don't know if there was a meritorious reason for that failure to appear. Mr. Harris tells me that he did, that he was in the hospital, and that I do know that he's still out on bond on that other case in Clinton County, but he did want me to bring that to the court's attention since the court did make a point of mentioning that. It seemed to be a very pertinent factor in the court's decision here today.
All right, thank you. Based on the representations of counsel, but we are leaving bond at 15,000 cash surety with that understanding. Thank you, everybody, for your appearance today.
Thank you, Your Honor. We are going to need a transcript request.
All right. All right, so we're on the record in docket 24-00888. That is people of the state of Michigan versus Zachary Newby. Will the parties please introduce themselves for the record? Mr. Stevens.
Andrew Stevens on behalf of people.
Ms. Wanji.
Good morning, Your Honor. Melanie Wanji from the Public Defender Office on behalf of Mr. Newby.
And sir, you are Zachary Newby, is that correct?
Yes, sir.
Thank you. This is time set for a preliminary examination today. Mr. Stevens, how are we proceeding?
Thank you, Your Honor. As I understand the sort of posture of the case, an examination was started but not completed. And one of the reasons for that is that the witnesses was in need of representation, is my understanding, both experience and speaking with Mr. Milks, who is present also, that representation goes through the Public Defender's Office. Mr. Milks is here if the court were to inquire or have any questions. As I understand it, at the moment, representation has not yet been secured, and so the examination that's scheduled for today by necessity or sort of good cause would have to be adjourned.
Okay.
And certainly the people don't have any objection to that. And I think there's just one matter that Ms. Wanji would like to address sort of beyond that as well.
All right, so this was an examination that had been started. Counsel was to be appointed by the Public Defender's Office. Well, it goes through the Public Defender's Office in regards to Fifth Amendment rights concerning self-incrimination. My understanding is that conflict counsel has not been set. Is that correct? Mr. Milks, you're here on that?
Sorry, Mr. Stephen Milks, Your Honor, from the Eaton County Public Defender's Office. I've been working with Ms. Harrison just to try to get conflict counsel confirmed with my office this morning. They did receive the request, I think back in April 14th or 18th, I can't remember the date. They did get the request. They're still trying to find conflict counsel at this time, but we expect that should be relatively soon.
All right. All right, so Ms. Wanji, you do have something to address with the court, so you may proceed. You understand the nature of the adjournment for conflict counsel in regards to getting the witness some representation and some explanation of the Fifth Amendment right. Ms. Wanji.
Yes, Your Honor, and I have discussed with my client what the problem that we have. And although he's not very happy, but we also understand what's going on. The other matter that I would like to address is the fact that both parties, my client and the complainant, they have a child in common, and there is a no contact order. And my client has been a little bit very leery to have a third party intervene. So we would like the court to allow him to have a third party communicate with the alleged victim regarding the custody and the care of the child.
All right, how old is the child?
It's going to be 3 on Sunday.
Okay, 3, and there are currently no family court orders in relation to the custody of the child?
There is none, because they used to live together, and the child was used to see the father every day.
So you're requesting a bond modification in regards to the third party, any contact with the child being association with to be through a third party, and then the third party would also be responsible for being present during any visitation.
Maybe just to drive the child and out of the
All right.
visitation, because I don't think that there is any concern about the care.
About coaching or anything, because it's a 3-year-old child, right?
3 years old child.
All right, Mr. Stevens, response.
Thank you, Your Honor. I appreciate Ms. Wanji signaling to me that this was something she wanted to address, because they gave me the opportunity to speak with Ms. Harrington about it. As I understand, in speaking with her, this was a relationship that existed before this. There was circumstances where there was a third party trade-off of the child. And so consequently, in speaking with her, she doesn't have any issue accommodating this. If I recall the conversation correctly, in the past, they've utilized Ms. Harrington's mother and or Mr. Newby's parents as a means to sort of trade off care and custody of this child. So with that understanding, I'll defer to the court.
All right, thank you. So I will modify bond to allow third-party contact for visitation of the 3-year-old child. And the third-party contact would be the grandparents or any individual that both parties agree to. Or any individual that parties agree to. So with that modification of the bond involving, what's the name of the child, the 3-year-old child? Zachary Newby. Okay. All right, and then we will adjourn this matter for conflict counsel to meet with the witness in order to explain any preliminary examination pitfalls that may exist concerning the Fifth Amendment. And we will adjourn to, how far out are we thinking in regards to that, Mr. Milks? We're at the end of May anyway.
Yeah, oh, then right at that time, Your Honor.
All right.
May 30th, I think is like the next available date.
Yeah, we're May 30th or beginning of June.
May 30th at 8:30.
May 30th at 8:30. So we will reconvene for preliminary examination to be recontinued. And once the witness has the opportunity to speak to counsel concerning some of the Fifth Amendment rights, we'll reconvene on May 30th at 8:30. Bond is modified to allow third-party contact between Zachary Newby, the 3-year-old, and the third party in relation to setting that up in regards to any visitation. Anything else, Mr. Stevens?
Nothing, people judge, thank you.
Anything, Ms. Wanchi?
No, thank you.
Anything else, Mr. Milks, on behalf of the witness?
No, thank you, Your Honor.
All right, thank you. You're all set. Thank you for your appearance.
Thank you, Your Honor.
Aaron, you wanna go next since it's your turn?
We couldn't have touched on it.
He's not.
He's not,
Okay.
but I'm.
You're fine. It's fine.
Like
I remember
said,
that. You weren't sure if he was.
Yeah, I went and I looked around, I still don't see him, but he's never. in shape, so I think it's my fault.
Sure.
For the clerk's part, and then you can, and I tried to do the bind over, but you should probably check.
Yeah,
I had typed in all the codes of the other ones, meeting
good.
them, so I had them all, so I can go back.
I'll just,
Yeah, but I would double check my work, and
Yeah.
that was a lot.
Let me think.
Mr. Mills,
One of you gentlemen hand, Ms. Wanji's client a copy of the NTA that's on the.
Yep.
oh, I could have done
Oh, I'm
that.
sorry,
I'm
Mr.
right
Ray, I
here.
didn't see you.
No
I'm
worries.
sorry, I
could have grabbed it if you told me it was there.
I'm sorry, I kind of forgot that my court officer had stepped out for a moment.
I have 2 copies here.
One for him, and if you would just leave one there, and Athena will take care of it.
Alrighty.
Thank you so much.
Good, Judge, thank you.
thank you, Mr. Milks.
You want to continue whisper next?
Yes.
Sure.
I know how to do it.
This is recorded. You get to do whatever you want. but-
If we could, that would be fantastic.
Whisper is fine.
Yes. Oh, no worries.
Right.
Charger for a second? Or did I, yeah, it's too late. You already unplugged. No.
So we're on the record in docket 24-00909. That's people of the state of Michigan versus Darnell Risper. Will the parties please introduce themselves for the record, Mr. Stevens?
Interested on behalf of people.
Ms. Schroeder.
Sorry, and Aaron Schroeder on behalf of Mr. Risper, who's not here, but I would ask the court for a chance to explain that with regard to what's going on.
All right. So this is time set for preliminary examination today. Ms. Schroeder, you can make a record as to your client's non-appearance.
Thank you, Your Honor. Now, when I was reached out to by Abigail Wilson, prosecutor on this matter, on I believe it was Tuesday, may have been Wednesday, regardless. Indicating that one of her witnesses, one of the state troopers, was not going to be available for preliminary examination today. We went back and forth as to the best way to approach that, as I had other matters already pending in other courts. And it made most sense to just ask for adjournment, as this 21 days on this matter had already been previously waived on defense's motion because of school conflict in the client. I relayed this to Mr. Risper, but I did not have a chance, and he has always shown for court. He's always been very responsive to me. I suspect he was at work, and I may not have been clear that he still needed to appear for today. I relayed that the case that was going to be adjourned due to the trooper and my issues also with potential scheduling. I may not have been clear that he needed to still appear for court, which I believe explains why he is not here. I do not believe that this is him just not showing up. He always is here and he's been very responsive. I'd ask the court not to bench warrant him, and just that since we were already going to be asking for an adjournment, get a new date, and I will make sure to follow up with him further.
Mr. Stevens.
Your Honor, Ms. Schroeder is correct. As the court knows, I'm standing in for Ms. Wilson due to illness. She provided me with a laundry list of notes, specifically as to Ms. Risper. Mr. Risper, as Ms. Schroeder indicated, was all accurate, that one of the witnesses was unavailable today, and even was able to provide me additional dates in the future, that being May 31st and June 16th, that witness is unavailable. As a result, in speaking with Ms. Schroeder, when she revealed that Mr. Risper isn't here, I informed her that I would not be moving for a bench warrant. Certainly the court has its own discretion and authority to authorize one anyway, but I'll defer to the court on that. And as for the adjournment, as Ms. Schroeder indicated, everything we've covered is accurate.
All right. I also have an email from indicating that this was to be adjourned based on the conflict of one of the witnesses. Mr. Risper has appeared on April 11th and April 18th. So I have without objection from the prosecutor, I have no problem adjourning the preliminary examination and not issuing a bench warrant. Suffice to say, if Mr. Risper doesn't show up next time, we're going to have a problem.
Yes.
But we will adjourn the preliminary examination based on the stipulation of the parties. The waiver of the 21-day rule was April 18th on 2024. And I will reset for
May 31st and June 16th.
May 31st and June 16th. May 30th at 9?
That isn't on the list.
All right.
I presume that's okay.
Good. May 30th at 9 o'clock for the preliminary examination. And Ms. Wilson will let us know if that date doesn't work. Anything else for the record in 24-00909? Mr. Stevens.
Nothing from the people judge.
Ms. Schroeder.
Just to confirm, that was May 30th at 9 a.m.?
Correct.
All right, nothing further. Thank
All right,
you.
thank you.
All right.
Yeah. Is that Mr. Travis?
Yes.
Yeah, I'll just throw this in there. Well,
All right, so we're on the record in 24-00546. That is people, the state of Michigan versus Clifford Travis. Will the parties please introduce themselves for the record? Mr. Stevens.
Mr. Stevens, on behalf of people.
Mr. Hardy.
Assistant Public Defender Joseph Hardy, on behalf of Mr. Travis.
And sir, you are Clifford Travis, is that correct?
Yes, sir.
All right, thank you. This is the time set for a contempt hearing concerning some bond exclusion violations. Mr. Stevens, we have had the opportunity to speak with yourself, myself, and Mr. Hardy in chambers. Did you want to make a record of any type, of any kind, from the people's perspective?
I'll reserve that. I plan to sort of defer to Mr. Hardy because I think most of it comes by way of him on behalf of his client, based on the conversations that I've had with him, Mr. Hardy individually, and then with you, Judge, in your office. I think everything will be addressed, and if I need to add a finer point, I will.
Okay, thank you. Mr. Travis, Mr. Hardy.
Thank you, Your Honor. So at this point, just as we discussed, we would just be requesting a reduction in the zone first from 2,000 to
1,500 feet, just because of the specific location of the alleged victim's job at Atlanta Looking Stadium. Right smack dab in the middle of downtown. We believe that by tricking the zone, that will allow him to traverse east to west and west to east on Kalamazoo and avoid Michigan entirely. Additionally, just regarding any transport to and from work, we would just request that he be allowed to provide proof of his employment, along with the address, hours, and anything else that's relevant for his job at R&D Lawn Care and the soup kitchen, just for him to be able to earn an honest living without committing any more violations here.
Thank you. Mr. Travis, you understand why we're here today,
Yes,
okay?
sir.
And we have three zone exclusion notifications, and you're on a GPS, so you're being tracked, and there's been a violation. And I understand that some of those violations are just driving by.
Can I say something?
Sure, you can say whatever you want.
I'm like, when my last court date, my tether was off because I couldn't pay it. But I did pay and got it on. So I'm like, I'm not stupid. I know it's GPS and I paid to get it on. Why would I do that?
Right.
And I just spent money to get it on.
But what we're going to do is we're going to reduce the exclusion zone to 1,500 feet, which should take care of this problem. Okay. The other thing is that you should have on your person, if you're going to and from work or for work purposes, any type of proof that you're. So if you're stopped, you have proof to say I'm going to work or I'm working within the exclusion zone, so that you can show. So that's for your protection, so you won't be violated. Okay.
Yes, sir.
That I think. So you understand the nature of it. The nature of it is that there's a no contact order. If you're in the exclusion zone and you're more than a few minutes, we're going to start wondering what you're doing, right?
Yes, sir.
And so that becomes a problem. Then we're in here again, and we want to avoid that. So this is for your protection as much as anyone else's. So what I'm going to do is I'm going to modify the bond to reduce it from 2,000 to 1,500 feet, and also exclude any employment proof. So as long as you have proof of employment that you're coming or going, or you're working at the shelter, if you choose to work there, as long as you have some notification, that would suffice. All right.
Yes, sir.
Anything else, we're going to start wondering about, why you're there for 15 minutes, why you're there for 20 minutes.
And Your Honor, we would also just like to be able to see if we could zone out or make an exception also for our office, because it is.
Yeah, I would indicate that the public defender's office and any going to the public defender's office should be part of the modification, so that you can meet with your lawyer if need be. Okay. But that should be set up so the public defender's office has some report or some documentation that you're meeting with them. So just the same as your employment.
Yes,
What I'm asking for is proof. Okay.
Yes, sir.
And so if the public defender's office comes and calls me or says, yeah, we had a meeting and blah, blah, blah set up, I'm okay. It's in violation of no contact order where we're going to have a hearing. Okay.
Yes, sir.
All right. So I would make a part of the modification of the public defender's office with any proof, of course, of meeting with attorney. Anything else for the record? So at this time, with the modifications of bond, we're not violating your bond. We're just explaining it. So it's all set for, you're set for your sentencing on June 10th. Is that correct?
Yes, sir.
Okay.
And I got probation tomorrow and anger management.
Okay.
I started tomorrow. Till I get sentenced. So I got a hearing in the morning.
All right. Anything else for the record, or anything for the record in 24-00546, Mr. Stevens?
The only thing I guess I would ask is as to the status of these pending violations. I mean, it is scheduled for contempt hearing.
Yeah, I'll dismiss, you can, I can dismiss them based on the circumstances that we just discussed.
Okay, and that's fine. I just wanted documentation wise what the status was. Thank you, Judge.
So I'll dismiss the exclusion zone notifications for reasons articulated on the record, okay, for
Yes, sir.
reasons we discussed.
And this would be for the dates of April 20th, April 28th, and May 2nd.
Correct.
2024.
Correct. Yeah, we got an exclusion zone this morning, so for 2 minutes. So
Hey, I'm
you-
coming to court.
Yeah, so we know it's a problem, okay, we know it's a problem. So we will act, so we're gonna act accordingly, but to protect yourself, you should carry proof of the meeting or proof of employment. And then we've reduced the zone from 2,000 to 1,500 feet, okay, sir?
Yes, sir.
All right, Mr. Hardy, anything else for the record?
No, Your Honor.
All right, you're all set, Mr. Travis, thank you. for your
Okay, thank you, sir.
Thank you, Your Honor.
Thank you.